Hello and welcome to today's webinar, Top Patent Law Stories of 2020. My name is David and I'll be in the background answering WebEx technical questions. If you experience technical difficulty anytime during the event, please submit your technical issue in the Q&A panel and I will assist you. Please note that as an attendee, you're part of a larger audience today. However, the attendee list is not displayed. All attendees will be in a listen-only mode for the duration of today's call. And as a reminder, this call is being recorded. I would now like to introduce your first speaker for today, Donald Zune. Don, you now have the floor.
Thank you. First of all, I want to thank everybody for attending, especially given that it's Inauguration Day. Today, hopefully you've got your DVRs recording the swearing in, since it's going to take place probably towards the end of our presentation today. I know I'm recording it. Also, I wanted to start off with some housekeeping notes. So please note that all registrants for today's webinar will receive an email from MBHB within 24 to 48 hours containing a PDF copy of the PowerPoint and a link to an archived audio version of today's presentation. For those participants seeking CLE credit for today's presentation, please note there will be 2 randomly placed PowerPoint slides inviting participants to complete a simple online poll question. You must complete both poll questions in order to confirm your active participation and thus be eligible to receive CLE credit. And we'll point those slides out when we get to them. You're not going to miss them. We encourage you to submit any questions you may have during the webinar presentation using the WebEx online question submission module. Time permitting, and usually it's not, we will attempt to address submitted questions at the end of the webinar. If time does not permit, we will respond offline after the webinar. Frequently what we do is, if there are a lot of good questions, we put them up on the blog and answer them there and then have an online discussion with any readers who are interested in doing that. So without further ado, let's get after it with the presentation. So for the past 14 years, the Patent Docs weblog, for which myself and Mike Barella and Kevin Noonan are all authors, we put together a list of the top patent stories for the prior year. We go through all of the posts that we put up, pull out the ones we think that are good, kind of organize them, and come up with a list. We don't confine ourselves to a set number of topics. And this year, this past year, 2020, because of the pandemic probably, our list is not that long. It's only 8 topics long, and here's the list. Sometimes it's, over 15 topics. It really depends on what's out there, but like I said, we don't confine ourselves to a certain number of topics. Also, for the past 9 years, including this year, we've taken that series of posts and converted it into a webinar, which is what you are listening to right now at the moment. Now, in past years where we've got 15 or more topics, it's not possible in an hour and 15 minutes to cover all 15, and that would be, we'd be paying a little bit of attention to each of the topics. So we tend to pick out topics that we're going to focus on for the webinar, and if you're interested in the other topics that are on the list, you can just go to the blog and take a look at the list there. And we've got links to all of the stories that are related to each given topic, so you can go back and take a look at those or refer to them in the future if you need. So here's what we're going to talk about today. So I'm going to talk about our top topic, which was the impact of the pandemic, the COVID-19 pandemic on patent practice. And then Mike's going to talk about American Axle and patenting and artificial intelligence. And then Kevin's going to close by talking about the CRISPR interference, which he's been covering for the past couple of years. And it's a couple actually interferences, but one primary one that he'll be talking about. And then Kevin's going to touch on doctrinal equivalence. The second year in a row, we've got a lot of cases or some cases coming on that. And then he's going to finish up with touching on sovereign immunity, again, something that's been out there for a couple of years, and we've got a couple more cases that have come down. So turning to the pandemic, I think it's a good place to start, at least I feel it's a good place to start, with a joint message that the USPTO and the JPO, Japan Patent Office, issued in June. And in this, both offices, I think it's a little unusual for offices to issue letters like this, but it was really a nice gesture. But they expressed their heartfelt sympathies to the victims of COVID-19 and their families. And so I want to start off by saying that Patent Docs and MBHB also express our sympathies to all the victims, their friends, and their family. It's been a really tough year. Yesterday, we had an unfortunate, terrible milestone where we got to 400,000 deaths in this country. So it's been a really, really bad pandemic, as we're all aware. It was interesting because when we put the series of posts up about the top stories, one commenter thought that maybe putting the pandemic first was not really the right place for it. And I actually disagree. And I think that the pandemic has changed everything. I wrote in the top stories a post about the pandemic that if you think about the who, what, where, why, when, the pandemic has changed, how we work, where we work. I don't know about all of the attendees, but I've been working from home since March 12th. And without going into the office, there are a lot of office restrictions for those of us. And also, I think it's affected what we work on. So it's had, in my opinion, a really huge impact on not just the patent industry, but on all industries and on the economy for the country and for the global economy as a whole. It's had an impact on the entire planet. And so I think it justifiably is the top topic. So I wanted to talk a little bit about a timeline or provide a timeline because it's been about a year. So if you go back to December 30th of 2019, that's where you have the first identification of this virus that had not been named yet and for which a genome sequence wasn't available yet, the first detection in a patient sample in China. And if you, tomorrow will be the 1 year, I don't want to say anniversary, that's the wrong term, but it'll be a year since we've had the first identified case in the US, which was in the state of Washington. And so a lot of what has happened in a very, very short time frame. And then, as I mentioned earlier, the World Health Organization declared this a pandemic on March 11th, and I think we probably all remember that. So the second part of the timeline, this is more about innovation. And I don't want to discount innovation that impacted testing and PPE, because there's been a lot of innovation that has impacted that. And we'll touch on that towards the end of my time discussing the pandemic. And so this slide here really focuses on some of the therapeutics. So you have remdesivir, and you've got some antibody treatments from Lilly and Regeneron, and then the first two of a series of vaccines. The vaccine development has been unprecedented. In fact, all the therapeutic development has been unprecedented in its speed, but especially the vaccine, going from, in just a span of months, from not even knowing about this virus to having vaccines with the efficacy that these vaccines have been tested out as having is unbelievable. And while we've had a lot of death and a lot of folks have contracted COVID-19 and have been impacted by it because there's a lot of other things that are associated with getting the virus or being infected with the virus. Even with all of that, we've got these vaccines, and so hopefully 2021 will be a much better year as the vaccines are rolled out, and the vast majority of Americans and global inhabitants are all vaccinated. So let's talk a little bit about the Patent Office response, and I don't want to spend a lot of time on this because, in most cases, these were all responses that no longer exist. There are a couple programs that I'm going to touch on that are still out there. But like I said, for the most case, these were responses that happened right after the pandemic was declared in March. And there are a couple countries, I think Argentina is about ready to restart their terms for response. But most of the offices have long since passed the extension. And also I put this list up, and I've got a couple other slides with some other patent offices, because it shows you the diversity of response. So you had some offices like WIPO and IP Australia and the New Zealand Patent Office that really didn't do anything with respect to changing their processes or extending deadlines. And then you had others like the European Patent Office that's here on this slide, where deadlines were postponed for a little bit of time, in this case out to April 17th. And then at least patent prosecution started to get back to the way it had been pre-pandemic. And another thing you see is that there was a change in the way some patent offices approached it. So the Mexican Patent Office down at the bottom, they did not initially suspend their terms or deadlines, but then eventually did. And then you also see this pattern where the extensions keep getting extended further, as it was done in the Canadian Patent Office. And we're going to talk in a few minutes about the USPTO, which did kind of the same thing. Then you have other responses, like in the Israel Patent Office, where, not much changed. There was no suspension of deadlines for filing new applications, responding to office actions, paying renewal fees, or filing PTE requests. But there was this opportunity in certain circumstances to request an extension, but very, very limited circumstances from what I understand. What I did in my own practice was, take advantage of deadlines where it was very clear that they were being offered, where the Patent Office made it very clear that they were not going to be taking these cases up, and they maybe sua sponte extended the deadlines. And then with U.S. Prosecution, for example, not taking advantage of some of the things that I'm going to talk about in a few minutes. Okay, so let's move on to the U.S. Patent Office response. So the very first thing the Patent Office did was close its offices to the public on March 16th. Again, very common for a lot of the offices around the world to close and just allow only key personnel into the building. And then the next thing they did was they waived the petition fees for revivals. This waiver went out to June 1st and then was extended to June 30th and then was extended to July 31st. But the waiver is no longer in place. So you have to, do the ordinary types of, take the ordinary types of actions and pay the ordinary types of fees to revive once again. Also, Patent Office waived requirements in certain cases where you had to have a handwritten signature. That's one thing that we've seen from a lot of the patent offices. There are patent offices around the world, and I've had firsthand experience this, in the past, in the fall, where they require legalized documents. They require an original legalized document. And they require an original executed document. You're seeing a lot more flexibility from patent offices where things can be filed electronically and there's no longer the requirement for original documents. Personally, I think that's long overdue. And, I would like to see all offices go to a place where, scanned copies or certified copies would be sufficient if filed electronically. And we're moving in that direction. The Patent Office also, the USPTO also extended certain deadlines falling between a date range. And again, like a lot of their other actions, this was extended once, twice, and 3 times. But with certain caveats that I'll talk about in a minute. One thing that was implemented that's still with us is this COVID-19 prioritized examination pilot program. And again, I'm going to talk about that in a few minutes. The Patent Office also waived the prohibition against filing PTE applications online, so you could do that. And the Patent Office also notified the community that they were thinking about making this permanent. Again, I think that's long overdue. Instead of requiring 2 paper copies to allow you to submit it electronically via the EFS. They also said they were going to do the same thing with plant patent applications, and that might be made permanent, or likely will be made permanent as we move forward. They extended the time period for petitioning for restoration of priority right. So if you had, so ordinarily you've got 12 months plus 2 months, that comes through the PLT, the Patent Law Treaty. You get this extra 2 months to go back and file a non-provisional off a provisional if you missed the 12-month deadline. And so because of the pandemic, they extended that out to July 30th, or the later of July 30th, or the expiration of that 2-month time period. So they did not do this with respect to international applications because they didn't have the authority to do that, but they did waive the petition fee. So you're still stuck with that 2-month window that's in place ordinarily, but now for at least for things that occurred, 12-month deadlines that occurred between March 27th and July 30th, they waived the petition fee. And then the last thing, and I'm not going to go into too much detail about it, was they implemented this deferred fee provisional patent application pilot program. And what it allows you to do is defer the payment of the provisional filing fee until it comes time to file the non-provisional. So you've got to pay that fee in order to file a non-provisional claiming the benefit of the provisional. That's a statutory requirement. But the Patent Office allowed you to defer that fee. However, it's not free. It doesn't come with no strings attached. You had to agree, or you have to agree. I think this pilot program is still in place. You have to agree to have the technical subject matter of the provisional application published on the USPTO website. So I haven't personally taken advantage of this, and I'm not sure that I would, but it's there and available, and I guess you should know about it. Okay, so I think this is the last slide on that. So we're going to talk a little bit about the extension very briefly. So, and again, because it's not really in place anymore, but the extension of deadlines in the USPTO that occurred at the beginning of the pandemic, again, I mentioned that it had it related to certain deadlines and certain fee payments that occurred initially between March 27th and April 30th. And the Patent Office made it clear that they could not do this until the CARES Act got passed and until the President declared a national emergency, which I think that was on March 12th, if I remember correctly, or maybe March 14th. So once that happened, the Patent Office had the authority to enact these extensions, but it only applied to 12 types of deadlines, and 2 of these deadlines were only for small and micro entities. So there weren't a lot of deadlines that it applied to. And in addition, initially, it only extended the deadlines by 30 days. So that's not really a benefit. And I think that actually reflects the feeling that, you know, this is going to be 4 or 6 weeks and then we'd be back to normal. It clearly is not the case by any stretch of reality. But that, I think, was the feeling initially. And you also had to file this statement. So the statement is here. Again, personally, I did not take advantage of any of these deadlines for any of my clients. We just either, where necessary, sought extensions or filed things in a timely manner. Mostly I did that because I wasn't sure, and the Patent Office didn't give a lot of guidance to what that last part of the statement means, such that the outbreak materially interfered with timely filing or payment. And I just didn't want to be in a deposition having to explain the circumstances. So it just, for me and for my clients, it was better just to, you know, go on as business as normal, or as normal as possible. Also, they gave some relief before the PTAB. These deadlines were later extended. they got rid of the 30-day extension, and towards the end, the extensions only were limited to small and micro entities. So for large entities, everything started to move back to quote-unquote normal as of June 1st. So one interesting thing that came out was this letter that the director sent to certain Senate and House committees that had asked him to report on the office's transition to telework. I think that's very timely, considering that a lot of us are doing telework ourselves right now and have been for months. Talk about the status of filings and fee collections, and then cost-saving measures that the Patent Office was taking. And for telework, the director noted that about 88% of the USPTO workforce prior to the pandemic had been working from home at least one day per week. About half the employees were working full-time. And on March 23rd, the office went to mandatory telework for almost every employee. Only folks that absolutely had to be in a USPTO office were allowed to come in. They provided some production relief to the examiners during this transition to mandatory telework. As I said, they limited the number of employees who could go into the office. Like a lot of us, I think, our offices, to the extent that they might be open, are doing some of the same stuff. The office established strict safety protocols, again, something that we see around the globe, and provided PPE for employees. Patent filings and fee collections were not surprisingly down at the beginning of the pandemic, so they took a hit. And the director noted that a prolonged economic downturn could force the Patent Office to go to its reserves and start drawing on that. In fact, because of the fee relief that was offered, that's exactly what had to happen. That the Patent Office went and started pulling funds out of its reserves. And the director closed the letter by asking Congress to give the office the authority to spend diverted fees that had been collected between 1990 and 2011. And a report in August of 2014 pegged the amount of these fees at about $1 billion. So there's not a small amount that the Patent Office can't currently touch. For the prioritized examination pilot program, this is geared only to small and micro entities, and it basically is prioritized examination with a few caveats, and it allows the smaller micro entities to get into this program and not have to pay the prioritized examination fee or the processing fee, and get the same benefit of accelerated examination. And again, because of the very quick timelines for products and processes and things related to COVID-19 and the virus, having an expedited examination system is really important. The caveat is that you have to certify that the claims cover a product or process related to COVID-19, and that such product or process has to be subject to applicable FDA approval. There's also other couple caveats, and you can take a look at these when you get the PowerPoint. I just closed by saying that the pilot program started on May 15th. It was going to be limited to 500 requests, and at the end of December, the Patent Office announced that it had granted 251 requests already, and that 33 of these applications or patents had either been allowed or issued. Now, because many of these applications haven't even published, it's not easy to identify them. But I went and took a look to see just how many patents have been out, COVID-19 patents are out there. And so I looked for patents that had COVID-19 or SARS-CoV-2, which is the name of the virus, in the specification or claims. And keep in mind that the virus has only been named since February, and the disease has only been known since, about that time, January or February. The genome's been out since January. So there hasn't been a really long window, and yet was able to find 35 patents that where you had the terms in the specification or claims, and they're directed all kinds of things. So you've got kits and methods and systems for detecting and diagnosing. You've got methods of treating. You've got PPE, face masks, methods of disinfecting, social distancing methods, healthcare processing systems, antibodies that bind SARS-CoV-2, and teleconferencing methods, because we're all doing a lot of teleconferencing. And here's a breakdown of those patents and how they were accelerated. Again, the COVID-19 prioritized examination. So of these 35 patents, 11 went through that process. It only applies to small and micro entities. So if you're a large entity, you have to go the track 1 route. So 16 of these patents have gone that route. 5 others have been made special under Rule 102C, and 2 went through the first action interview pilot program, and 2 were accelerated in any way I could tell, and just went through the normal channel. And on the far right-hand column, you see the average days from filing to issuance. So these things have gone very quickly. And the last thing I want to talk about is of these 35 patents, the one that had the record for shortest time, and also because I thought it was interesting what patent it was. So of the 35 patents, they took between 58 and 230 days from filing to issuance. And the one with the 58 is the 735 patent, which I noticed back in mid-August because it was in the news in July. Not the patent, but actually the compound and the treatment. So the claim is a method of treating COVID-19 using oleandrin. And if you remember, this is the compound that was promoted by the MyPillow guy to the president at the time as being a therapeutic for COVID-19, even though I could not find a clinical trial at the time. I mean, maybe there's one out there now. They were some other oleandrin clinical trials because oleandrin's been around for a while, but nothing related to COVID. But they got a patent in 58 days for treating COVID-19 with oleandrin. And so here's your first slide for getting CLE credit. So what you want to do is punch stories, the word stories, into the poll module and hit submit. Don't forget to do that. If you don't hit submit, it's not going to go in. If you have any issues, our producer will help you out with that. But we're going to leave this slide up for a few seconds. So I'm going to turn it over to Mike, who's going to talk to us about the next topic on the agenda. But we'll leave this slide up for a few seconds. Mike, it's all yours.
All right, thanks a lot, Don. And unlike Don, I actually did take advantage of the COVID-19 programs at the USPTO for at least a couple of my clients who were particularly interested in or affected by COVID to the point where they had to take some delays in responding to office actions or paying issue fees. And it seemed to be just fine. You file the statement, and there's a standard form for doing that. And we really had no issues at all. So that aspect of the COVID program at the USPTO seemed to be moving along pretty smoothly. All right, so I'm just going to leave this slide up for another couple of seconds. Please go ahead and enter in the word stories into the WebEx poll, hit submit, and then we're all good. If you don't hit submit, we won't receive it, so please hit submit. Don't worry about typos. If you type anything that looks like stories, we'll give you CLE credit. We're just that nice. All right, so moving along, our next story, we're changing the tone and the tenor a little bit. I mean, COVID was a really dark time. It continues to be a dark time for us, but we're going to move on to something else, and that is, in particular, the ever-present concern in patent law about patent eligibility and Section 101. Section 101 has been a top topic on patent docs for many, many years now, especially since the Alice versus CLS Bank case. So even though most of you are probably aware of this case, the current standard for patent eligibility as set forth in Alice is that even if you have a claim that is otherwise statutory, so it's a you're claiming a machine, an article of manufacture, a process, a composition of matter, it can still be found ineligible if it doesn't pass the Alice test. What's the Alice test? Well, it's two parts. The first part is you determine whether the claim is directed to a judicial exception, and there's three: laws of nature, natural phenomena, and abstract ideas. If the claim is not directed to one of those, you're good. You're statutory. If the claim is directed to one of those, then you have to figure out, well, does the claim embody an inventive concept? And an inventive concept, in the words of the Supreme Court, is that it's an element or combination of elements that's sufficient to ensure the patent in practice amounts to significantly more than the ineligible concept itself. And if that sounds a little vague, you're not alone. In fact, the last 6.5 years in the Federal Circuit has largely been trying to scope out what the heck these two prongs or these two steps of the Alice test really mean. And there's certainly some concern, and I've expressed this concern, and dozens and dozens of other patent attorneys and patent professionals have expressed the concern that the line of cases that have come out of the Federal Circuit regarding 101 since Alice has essentially turned the patent eligibility test into something of a Frankenstein's monster that stitches together concepts of subject matter eligibility, claim specificity, as well as prior art analysis. And that's what we're going to talk about today, because all of these notions come together in this American Axle versus Neapco Holdings case. So let's talk about American Axle. This is really the biggest 101 story we've had in a while. So as background, American Axle has the 911 patent. It is titled Method for Attenuating Driveline Vibrations. And what the technology is about is really methods for manufacturing shafts, drive shafts with liners, and the liners are designed to attenuate vibrations that are transmitted through the shaft. So if you've got vibrations that are going through a drive shaft, then you're going to have a more uncomfortable ride if it's in a car or truck, for example. It might make some noise as well. It might wear the assembly in various ways. So there's a number of very good reasons why you want to attenuate these vibrations. And in the prior art, American Axle admitted that there are 3 different types of vibration modes, each of which have known techniques for being individually damped. So these are bending modes, shell modes, and torsion modes, and there are prior art techniques out there that can damp any one of these modes. But what American Axle invented, and claimed is a set of techniques for tuning a liner to put into a drive shaft in order to dampen shell and bending mode vibrations simultaneously, and they contended that this was unknown, and as far as we know, in fact, it was unknown prior to the 911 patent. So let's take a look at 2 of the claims of the 911 patent that were under dispute here, claims 1 and 22. We'll start with 22 because it's a bit of a simpler claim, and you can think of it as really having 3 substantive steps: providing a hollow shaft member, so there's your shaft, your drive shaft. Then you tune a mass and stiffness of at least 1 liner, and then get that tuned liner and you insert it into the shaft member, and it's specifically tuned in a way so that it's a resistive absorber for shell mode vibrations, and it's a reactive absorber for bending mode vibrations. Now, I'll be the first to admit that Claim 22, it's fairly broad. It talks about what the invention does without getting into a ton of detail about how it achieves that goal. And as it turns out, that was actually one of the main issues that the court had with this claim. But even if we look at Claim 1, which is arguably a very similar embodiment as Claim 22, it's just a little bit more detailed. You still got the hollow shaft member, but it's a little bit more specific in that it says that it's tuning the liner to attenuate 2 modes of vibration, and then it has a claim element about positioning the liner within the shaft member in a particular configuration so that you've got some attenuation occurring within some predetermined ranges, but still a fairly outcome-oriented claim. So procedurally, what happened was that back in December of 2015, American Axle sued Neapco for infringement of the patent. In the district court, a couple years later, in August 2017, both parties moved for summary judgment under Section 101, and Neapco won. And so the claims were, all of the claims were found to be ineligible, all of the asserted claims. In October of 2019, after appeal, a federal circuit renders a decision. And it was a split decision where you had a majority, Judges Dyke and Toronto, affirming the district court, and they found that claims 1 and 22 were in fact ineligible under Section 101. Judge Moore, however, wrote a very, very strongly worded dissent. So there was a lot of disagreement between the judges on this case, and not surprisingly, American Axle then requested for a panel rehearing as well as a rehearing en banc. With respect to the panel rehearing, something kind of unusual happened in that in response to the panel rehearing, the panel issued a modified version of its October 2019 opinion. It held the course about Claim 22 being ineligible, but it actually changed its mind to a certain extent regarding Claim 1. So instead of finding Claim 1 ineligible, it remanded the eligibility determination of Claim 1 back down to the district court. So the court actually changed the opinion, changed the language and text of the opinion. Judge Moore changed her dissent to some extent. But with respect to the rehearing en banc, it was a 6-6 split. So 6 judges wanted to rehear the case, 6 did not, and there were a number of opinions concurring and dissenting that were filed here. So in a way, this is really the biggest, most controversial 101 case to hit the federal circuit since Alice, and essentially it's a very similar pattern where you have a very close split between the judges on the court and many different dissents and concurrences being filed. So not surprisingly at all, in December, so really just about 3 weeks ago, American Axle filed for certiorari with the Supreme Court. And so we don't know how that's going to go. We don't know what Neapco's arguments are going to be like in return, but you can expect that there's going to be a lot of very interesting amicus briefs being filed over the next couple of weeks, as well as, hopefully a decision sometime this term as to whether the court is going to hear the case. And this would be the first case, the first 101 case heard by the Supreme Court since Alice, if in fact the grant of certiorari happens. So there are a number of issues of dispute in this case between the majority and the group that I'm going to call the dissenters, which would include Judge Moore, who wrote the dissent on the panel decision, as well as a number of other judges who wrote dissents separately for the denial of rehearing en banc. And I'm going to basically call out 3 main areas of dispute, even though arguably there's several more. And starting with the law of nature, what the majority found in their Section 101 analysis was that the claims in the revised opinion, this is Claim 22, is directed to Hooke's law, which is a law of nature. Now, if you remember from high school physics, Hooke's law is essentially a linear relationship between frequency, mass, and stiffness, and it's implicitly required in Claim 22 according to the majority. And so therefore, the majority believes that the claims are directed to a law of nature through Hooke's law. The dissenters, on the other hand, state very correctly, Claim 22 doesn't actually recite Hooke's law. And if we wanted to go back and take a look at Claim 22, which is just a couple slides back, and if you remember that, there's no Hooke's law. There's no equation. There's no mention of Hooke's law. And the dissenters go on to state that Hooke's law is not required to practice the invention, and more importantly, just because an invention applies with the laws of physics, it doesn't mean that it's automatically directed to a law of nature. Because if in fact you can say that an invention uses the law of physics, therefore it's directed to a law of nature, well then every single invention ever made would be directed to a law of nature. And that's not what the Supreme Court wanted us to do in its 101 cases. The other area of dispute of the 3 is the second one is outcome-oriented claim, and I mentioned this briefly before. Claim 22 recites a desired result and not any particular way of achieving that result, so it's actually very broad. And what we found over the last few years since Alice is that the Federal Circuit has really turned they frowned on outcome-oriented claiming, and they've been using Section 101 as a way of expressing their disfavor. So you can look through many, many 101 cases, at least several dozen over the last couple of years, where the court, in finding a claim invalid under Section 101, has criticized that it uses outcome-oriented claiming and essentially doesn't teach in the claim itself how to practice the invention. The dissenters, on the other hand, dispute that this is what the law even is. And they say that the majority's requirement that the claims and not just the specification teach how to practice the invention is improperly combining sections 101 and 112. And finally, we have dispute over the inventive concept. The majority decided in a very conclusory fashion, and that's my view after reading the opinion, that nothing in the claims or in American Axle's arguments qualify as an inventive concept under prong 2 of Alice. And that's about it. They didn't really get into much detail, but the dissenters did, and Judge Moore in particular pointed out numerous factual disputes between the parties about what the innovative concept is in the invention, and in particular the fact that you can damp two different modes of vibration simultaneously, which it seems to be no dispute that that is new. And each of these many reasons cited by Judge Moore and some of the other dissenters was enough to provide an inventive concept. At the very least, it should go back to the district court for further fact-finding under prong 2 of Alice, which fact-finding is now allowed since Berkheimer. So these are the three main areas of dispute between the parties. There were quite a few more. Okay, so now the question is, what about Claim 1? As you'll recall, initially Claim 1 in the first panel decision was found to be ineligible on similar grounds as Claim 22, but the majority changed its mind in the revised panel decision. And I think that this is an exercise in some very thin bacon slicing, because according to the majority, the fact that you've got elements of tuning the liner to attenuate two modes of vibration explicitly in Claim 1, and also the positioning of the liner being claimed, that goes beyond Hooke's law. So therefore, the majority states that Claim 1 is not directed to Hooke's law, and therefore it's also not directed to a law of nature. Again, we could debate all day long about the differences between Claim 1 and Claim 22 and whether this difference is significant enough, but that seems to be what the majority is now saying. And although this is really maybe not great news for American Axle that it's going back down to the district court, because the Federal Circuit majority has requested that, or has advised the district court to consider whether the claim is in fact directed to an abstract idea. So maybe American Axle wins on the natural law exception on Claim 1, but they very well could lose on the abstract idea exception. So they're essentially back to square one in the district court if this ever gets back to the district court. And one of the more interesting things about this case is that there has been some very, very strong language back and forth between the judges, just demonstrating how much disagreement there is on the substance and process of the 101 analysis in the Federal Circuit. And I think it's anyone who reads this case should be able to conclude by the end of it that there's a very serious intra-circuit split between the judges. Not only did they go 6-6, but they just disagree fundamentally on how the 101 test should be carried out. Judge Moore has some choice quotes, and she says that Section 101 is monstrous enough. It cannot be that use of an unclaimed natural law in the performance of an industrial process is sufficient to hold the claims directed to that natural law. She also believes that 101 has now been imbued with a new superpower, enablement on steroids. In other words, you have to enable the invention in the claim and not just in the specification. And also she brings up another procedural point, is that she accuses the majority of deciding a scientific question, a question of physics, as a matter of law on appeal for the first time. And she finds this wrong because she says, look, we're judges. We are not scientists. We are not engineers. We should not be deciding scientific questions as a matter of law instead of as a matter of fact, much less on appeal for the first time. So she has many, many issues, and she wrote a very long, strongly worded dissent. And you'll see other judges, Newman, Stull, O'Malley, and so on, also had some strong language criticizing the majority. And of course, the majority came back and attempted to justify their position as well. So again, to reiterate, this case is up for certiorari. We have no idea what the Supreme Court's going to do. Honestly, at this point, I wouldn't be surprised if it gets granted, and I also wouldn't be surprised if it doesn't get granted. The court, over the last few years, has been fine with letting 101 percolate. Maybe the Supremes don't quite understand how split the Federal Circuit is. Maybe at this point they will take the case up again, but nonetheless, that's where we stand as of today. We should know maybe within about 6 months by the end of the judicial term whether the court is going to grant the request or not. All right, so let's smoothly move along to a fairly different topic, but one that still touches on Section 101, and that is patenting and artificial intelligence. And artificial intelligence, even in the age of COVID, with all of us sitting at home, there's still a ton of chatter about the virtual water cooler, about what's going on in terms of AI and machine learning, and in particular, how it is affecting virtually every aspect of science and technology and innovation. AI is literally everywhere, and it's across fields. It's being used for all kinds of really interesting applications. So, for example, genetic similarity, figuring out if your DNA sequence is similar enough to someone else that you might be their relative. Natural language processing, so keep this in mind the next time you get into an argument with Siri or Alexa, you're actually talking to an AI. Targeted advertising, so when you go on social media and you're wondering why some ad pops up from some website that you were recently visiting. Business process improvement in the enterprise, image classification, facial recognition. This is really just a very short list. Any problem that has a lot of data, enough to train a model, is a candidate for using artificial intelligence. All right, so let's get our nomenclature straight. What do we mean versus when we say artificial intelligence versus when we say machine learning versus when we say deep learning? These are three terms that tend to be used somewhat interchangeably, and arguably at least some of them shouldn't. So let me try to define what I mean by these terms. AI. Artificial intelligence is using human-related or human-based intelligence in the form of rules to solve problems. Machine learning, on the other hand, is a computerized process to train a model, essentially train a program or an application that can form its own rules to predict solutions to problems. And finally, deep learning is really just a special case of machine learning that uses a much, much larger, more complicated model, vast data sets, multi-layer neural networks with hundreds, thousands, or millions of nodes. I don't think that there's a huge distinction anymore between deep learning and machine learning, but you'll see those two terms thrown about. I think there is a fairly machine learning is a fair subset of AI, but it happens to be one of the most, if not the most, active areas in AI. So when we talk about machine learning or deep learning, what do we mean from a technical point of view? What's different? What's going on here? Take a look at the upper right corner. If I am a programmer, I am going to get some input, production input, and I'm going to want to produce some output. So I want to write a program that takes that input and correctly produces the output that's desirable. And I'm usually going to have someone tell me, you get input A, you produce output B. You get input C, you produce output D, and so on. That's traditional programming. What's different in machine learning is that we have these input-output mappings, A to B, C to D, and so on. Maybe we have thousands or millions of them. We put them into a training program, which is essentially an algorithm that creates a model, and the model then can take the production input and predict what the production output is. Now, if that sounds like a little bit of science fiction, on paper, yeah, it sounds a little sketchy. Can a computer really do that? But in reality, these models are so sophisticated now that for certain specific tasks, a well-trained model can perform as good or better than a human being. Image classification is a great example of that. Handwriting recognition is a great example of that. So yes, this is being used. You may not be aware of it, but you are actually using these models indirectly all the time. So let's circle back to patent law. One of the questions that a lot of people still seem to have is, well, is machine learning even patent eligible? I mean, can you even get a patent on it? And there's a couple of arguments that have gone back and forth. The common argument is that machine learning is you're really just using a lot of abstract math, so your machine learning claims are, they undoubtedly incorporate an abstract idea, and you're not really improving a technology, you're just crunching a bunch of numbers inside of a computer. On the other hand, you could argue that machine learning is actually solving complex technical problems, like some of the ones we discussed earlier, creating new algorithms that in practice can only be used on computers, so therefore machine learning techniques are fundamentally tied to computer technology, and therefore they're fundamentally technical and should be eligible. There really is no bright line between these two. So that means that in practice, how you write the claim and how you specify the machine learning technique in your patent application and how you argue that in front of a patent office really can make a difference. There's no bright line. And with respect to patent eligibility, machine learning inventions are, in fact, evaluated under 101 on a case-by-case basis. And we've seen no court do anything special with respect to machine learning. In fact, as of today, the Supreme Court and the Federal Circuit, neither one have actually heard a subject matter eligibility case that was directed to a core machine learning invention. And if you look further into the district courts, here's a handful of cases that I was able to find on machine learning. There may be a couple more recent ones that I'm not aware of, but none of these cases were really directly related to the guts of how machine learning works. All of these cases where a district court found claims to be in all cases ineligible, were tangentially related to machine learning or to AI. So I think that this is an open issue, and the courts haven't really thought hard or addressed the patent eligibility of these inventions, but I suspect when they do, they'll just say, well, it's like any other 101 analysis. But what about at the USPTO? Has the USPTO said anything about AI? And in fact, the answer is yes. They published a white paper back in October, and it covers a lot more than just patent eligibility. We're going to talk briefly about examination eligibility and a couple other topics, but it covers a number of topics, not just covering patents, but also trademarks, copyrights, trade secrets, search engines, data, security, and so on. And you can download this from the PTO. It's about 60 or 70 pages. It's a free download. It's worth reading. It's a pretty good document. We covered it on Patent Docs. So the two major questions that I'm going to focus on in the few minutes that I have left here is, do AI-based inventions require special examination procedures, 101 or otherwise? And can entities other than a natural person be an inventor? In other words, can we have a machine be an inventor? So one of the things that the PTO did that I thought was really useful is it said that it came up with a categorization of AI-based inventions into three buckets. Bucket number one are inventions that embody an advance in the field of AI. In other words, the invention is making AI better, faster, more efficient, using less memory, giving you better results, and so on. So it's improving the internal structure of an AI or machine learning system. Bucket number two would include inventions that apply AI to some field other than AI. So if I'm applying AI to genetics, my invention falls into bucket number two. If I'm applying AI to natural language processing, my invention falls into bucket number two. And finally, bucket number three, which I think is very shallow and maybe there's nothing in there, is a set of inventions that are produced by AI itself. So with respect to eligibility, the Patent Office wrote that AI-based inventions are really just a special form of computer-implemented invention, and since Section 101 is the current Alice test is it's a universal test for any invention. So therefore, there's nothing special that the Patent Office has to do with respect to examining these inventions under Section 101. Now, in contrast, the Japan Patent Office and the Korean Patent Office do have specific and dedicated AI examination units that may apply a slightly different examination procedure. The USPTO, I believe, does have an art unit or two that is focused on AI, but AI-based inventions are really examined by a number of art units within the PTO. Just like computer-based inventions, they can land in all different kinds of art units. Also, and this circles back to something that we discussed a little bit earlier. Some commenters to the Patent Office indicated that they thought AI-based inventions were all abstract ideas, right? But the Patent Office pushed back on that and said that really to the extent that these inventions provide technological improvements and amount to significantly more, so they have an inventive concept, they would pass through the Section 101 filter. And, in particular, this this procedure that the Patent Office is setting forth is in fact very consistent with how the Supreme Court has refused to draw a bright line between what is and is not eligible, and each invention is under 101 going to be considered on its own merits. And finally, we have inventorship of a non-person. So can a machine, can an AI actually be an inventor? So let me take a quick step back. What is the current state of AI? The current state is that the current machine learning AI models are narrowly tailored to solve specific problems. So they're designed to solve a specific problem. They're good at solving those specific problems if they're well trained and well designed. And in fact, a superior model will arguably be better than a human being at solving certain types of problems. But there is no general artificial intelligence comparable to human intelligence out there yet, right? It doesn't exist yet. That is still science fiction. So in a lot of ways, the notion of who can conceive of an invention is really not a question we need to face just yet, because we don't have general AI. We have very specific, narrowly tailored AI. And to give you an example of that, let's say that I have a machine learning model that I trained to do image classification with 98% accuracy. That's a great model for image classification, but if I take that model and I try to do natural language processing with it, it almost certainly will be abysmally bad at doing natural language processing. So no matter how much the model learns about image classification, it can't generalize that to any other technology. That doesn't exist yet, as far as I know. All right, the patent statute also makes it clear that an inventor must be a natural person. So despite the fact that, arguably there's no AI available that can conceive of an invention, the patent statute in multiple places states that a natural person that a natural person is required to be, or an inventor is required to be a natural person. And even if a natural person uses AI to develop an invention, that person is almost certainly still the inventor. Now, this was tested. There's this U.S. patent application listed in the bottom bullet point that was purportedly directed to an invention made by a machine. The inventor was listed on the application data sheet as being a machine, and the USPTO, so far as I can tell, has refused to examine the invention on procedural grounds because inventions are required to have human inventors. Okay, so that ends my section, and if you would like to get CLE credit, please enter the word stories into the WebEx poll. Don't forget to hit submit. You will need to do that. We're going to leave this slide up for a few more seconds, and we're going to have Kevin take over and take things home. And by the way, it is noon in Washington, D.C., so congratulations, President Biden.
As I speak much more quickly than my co-panelists do, and I think I can be succinct. So I'm going to leave this up, but I am going to move the slide, because if you haven't figured out the word of stories yet, it's not going to happen. Okay, so I'm going to talk about first CRISPR, and I'm going to do two little pieces of history. What's CRISPR about, but not for long, and what happened the last time these two parties got into an interference. Again, I'm not going to belabor that, but just to bring everybody up to speed. It's called CRISPR because no one wants to say clustered, regularly interspaced, short palindromic repeats over and over and over again. But it's important because what this came from, remarkably, is from nature. And the nature is, it was the way bacteria became immune to virus infection, what they call bacteriophages. And the idea is they have this Cas9 endonuclease, and all that means is that it can cut up pieces of DNA from the middle and not from the ends. And in that, there are two pieces of RNA that were important, what they call the crRNA and the CRISPR RNA and the transactivating RNA. And this is important, and I only bring it up because, in fact, the difference between how nature does it and how it's done now and the subject matter of this interference is very important. So there we go. Jennifer Doudna and Emmanuel Charpentier figured out how to use this And initially they did it with 2 molecules, and then they figured out how to fuse them into a single guide RNA. And this is just a graphic that shows that you can actually have this, the purple thing is Cas9, and the piece of DNA gets in the middle and gets unwound, and a matching sequence comes in, and that forms the basis for repairing, for changing, all sorts of molecular editing in ways that the more traditional and cruder ways really can't do. And you can see this, people and mice and cells, these are all things that it can be used on. It can be used for agriculture. It can be used for a million things. And that's one of the reasons the interference is so important for a variety of reasons. This is just another graphic to show the 2 things you can do. You can cut it open, put it back together, in which case you've taken something out, or you can cut it open and put something in which case you put something in. So it's a very flexible way to do this. The first people that disclosed using CRISPR-Cas9 in eukaryotic cells were the folks, Zhang and colleagues, including George Church, who's really a giant in this field in Boston. So here's the cast of characters. Although interestingly, in the bottom one, not all these people were named as inventors, which doesn't really mean very much, but it will become significant when we get into the next interference. The first one was against all of these Broad patents, and one application from what is called in the interference CVC, California, Vienna, and Emmanuelle Charpentier, because she actually is named as the inventor and owner of some of these. So she's an independent inventor in that sense. And so this was the original one. If you know what interferences are like, there's interference count. And you don't have to read this. It's there for your leisure. There's nothing better to do. But the important thing is this A1 and A2, because it specifically recites in the count, and it means the invention that is being argued about has the target RNA, or otherwise called guide sequence. That's the sequence that's specific for every particular piece of DNA you want to edit, and this transactivator sequence that is part of the structural form of the way the molecule comes together to position the RNA and the endonuclease in the right way. So it's a 3-component system here. You have the protein and you have the 2 RNAs, and that was what was being argued about in the first interference. There are lots of motions that are typically in interference. The first section is motion practice, and the second section is actually priority. And here, the board didn't render any decision on any of that. They just had a motion from the Broad that said, there's no interference in fact. These things don't interfere with one another, and therefore none of the things that, if you go back and look, there were lots of juicy motions there, none of them, any of them were decided upon. And the good news for Broad is that they kept their patents, number one, and even California didn't do so badly, because there was no longer any impediment of the Broad patents getting in the way of them getting granted patents to their application, which was not limited in any way to specific applications to types of cells. The Broad was eukaryotes, the California's was any cell in which it would work. The reason? There's this 2-way test. You look at one of the applications and say, if it was in the prior art, would it anticipate or render obvious the other one, and vice versa? It has to be both. And basically the argument is, would Broad's claims have been obvious in view of what California taught in its applications? And the answer was no, because there are, as it says here, known differences between prokaryotic cells and eukaryotic cells. And unfortunately for California, there were statements made by the inventors in California that talked about their doubts of getting it to work in eukaryotic cells and the difficulties they had in doing that. And all of that was very persuasive to the board that you failed that 2-way test. And when it got to the Federal Circuit, they affirmed, mostly because these were, even though it was obviousness, as you know, there are factual predicates to obviousness. And after the Zirco case, you have a deference that's given to the patent office on factual questions. And so you have to, you apply the substantial evidence standard, and Broad easily met that. And you also had expert testimony. And so pretty much the decision was that, and it's important because it comes up again, that applying CRISPR to a eukaryotic cell would be unpredictable. And so they lost. So what does California do? They said, okay, we are now going to go back to the patent office and file a whole bunch of patent applications, and you see on the bottom of the slide all the serial numbers that are directed toward eukaryotic aspects, and also this other feature where you don't have two pieces of RNA, you have one. Okay, and so I'm going to show you on the next slide the count, and it's really a count in the alternative. This is just one of the claims. The patent office stopped doing actual counts and started just choosing claims. But here, the important part is the boldface italicized. The guide RNA is a guide sequence fused to the tracer sequence. And so very importantly now, two things. One, it's a lot easier to make one piece of RNA consistently than the other. That if it's going to work, you make it tied together rather than having to have two and have them come together in the cell and work. And that was important enough in eukaryotic cells, it seems, to make a difference. So there were two motions that are here that the board did argue about, and it also is here because this graphic's kind of cool. These four blue boxes are four provisional applications filed by the CVC inventors from May 25th, 2012, all the way down to February 15th, 2013. And the request, the motion, was that CVC should get priority all the way back to this May 25th, 2012. And the reason that was important, okay, is that if they did, they would then be the senior party. And if you remember interference practice, senior party is presumptively the party that wins, and the senior party is the one that has the earliest filing date. It doesn't matter when you invent it. To be senior party, you have to have filed. And this was pre first inventor to file, but it was the one place that when you filed made a difference. It wasn't dispositive, but it depends. And of course, in that case, since you're presumptively the inventor, you're not going to have to prove up as much as the junior party does. And CVC is the junior party here, as they were the last time. Senior party, Broad, also wanted to have earlier conception, or earlier priority date, and that's this December 12, 2012 case. And the board granted both motions. They granted the motion to the earlier case. This was the December application. They also granted Broad's motion, to the January application. Broad was the December application. Guess what? No change. The Broad is still the senior party. So there's quite a bit of motion practice that didn't get you anywhere, but it's something that's necessary in all these things because of what's at stake. So now we have the priority motions. This is the part that the board never heard in the first interference. And this graphic is from somebody's lab notebook, if you've ever had a lab notebook, and it points out using this single RNA species. And the conception date, the date that this was written down, was March 1st, 2012. And they actually then, CVC, said they reduced the practice on August 9th and October 31st, November 1st, 5th, and 18th. Okay? And the way they said is that we had this conception, and then we diligently pursued actual reduction to practice until we reduced the practice on all these dates. And of course, because the way interferences work, you don't get any respect if you're an inventor. Any of your testimony is given no weight unless it's corroborated. So they did have corroborating testimony for that. Okay. What does the Broad do? The Broad has this timeline that's very, very good. It says their first date of actually reducing the practice was July 20th, 2012. And they have all of what they did on the left side, and all the way down to when the December 12th application, which they call Zhang B1, was filed. And on the other side, they have CVC, and there's all sorts of language from the record about first shot didn't work on July 23rd, not detected on August 9th. We have a problem with RNA design in October. They also point out that there was a manuscript that was submitted in October by CVC and a patent application, P2, that they didn't get priority to, that didn't have the experiments they were relying upon in fish cells for their reduction of practice in eukaryotes, which Broad said is fairly suspicious. But the most important argument they made hies back to that the problems they were having in the first interference, according to Broad. And that is, if you remember, if you're old enough, back in the day when people were patenting DNA, there was this idea of simultaneous conception and reduction to practice, that you don't get to claim a DNA molecule until you actually have it. Why? Because it's so complicated, you can't have any expectation of successfully getting it until you actually get it. And back in the 80s and early 90s, it was a little difficult to know you're actually getting what you were fishing for in doing DNA isolation and cloning and all of that. So they were the first, according to their evidence, to first reduce it to practice. So applying the same rubric to them, they said, well, okay, if that's the rule, it applies to us. We did it in July 23rd. CDC didn't do it until much later. Therefore, we satisfy our own test, and we have the first to invent, because CDC alleged an earliest conception date, but they didn't have reduction to practice until after we did. And there was no reasonable expectation of success that they'd actually be able to reduce it to practice, given all of these problems that came out in the first interference about how difficult it is to get this to work in eukaryotic cells. So that's their positions. By the way, there are a few other things that have happened in the interim that you need to know about. One is that CDC wants to depose Luciano Marfini and Shualiang Lin. Dr. Marfini was involved in the inventorship dispute that gave rise to the Broad having its European patents, or several of its European patents, invalidated, revoked, because he wasn't named as an inventor and his institution wasn't named as an applicant. And Shualing was someone who was in Broad's lab, and in Zhang's lab at the Broad, and he has things that they think to say that would contradict, rebut, at least throw a certain amount of problems on the evidence that Broad is assessing. Now, we haven't had any decisions yet. These are just pending. They also have a motion for improper inventorship, and in that they've tried to hit the home run. Again, hasn't been decided yet. Whereas they've asked, because you have to ask for the remedy that you want, they've asked the board to invalidate all the Broad patents, and so that of course is more to come. The actual hearing will be in May, but what happens, just so we know, status quo, if Broad gets priority, Broad keeps all of its patents to eukaryotic CRISPR, and CDC keeps its generic ones, but I would venture to say that CDC would have a very hard time asserting any of those patents against somebody with a license to Broad's eukaryotic CRISPR. But much more importantly, if CDC gets priority, the Broad loses that original estate. So lots here, because there's lots and lots of licensing that's gone on here. You would expect there would be settlement, but there's going to be depositions anyway, not just the ones that CDC's asked for, so who knows. Okay, come on. There we go. All right, so we're going to talk about doctrinal equivalence briefly, and you all know Braver Tank, this is really a time when the Patent Office the Supreme Court actually thought that patents were something that were worth protecting. These are the things that can limit, and we're not going to go over those, but the biggest ones are prosecution history estoppel and the disclosure dedication rule, the Johnson rule. These other ones come up occasionally as well. Last year was a big year for doctrinal equivalence cases. And, these are now 6 cases, which I think are 6 cases more than we've had ever since the last time the Supreme Court spoke in Festo. And you can see that the court didn't just give a blank check, but doctrinal equivalence was, in the UCB case, was tied to known interchangeability. There was a lot of talk about the tangential relationship test, which was the test that the Supreme Court came up with for in Festo. And we're going to start with SCOTUS before we do anything else, and that is in this case, in the Lilly case, Eli Lilly v. Hespera, and Junimoto case, they wanted this question presented to be answered because back when the court came up with the tangential relationship tests, as it has with many of this, it gave deference to the Federal Circuit to figure it out. You can make an argument that what Mike was talking about also was the Supreme Court giving the Federal Circuit a chance to figure it out, but it hasn't really worked out that way. But because of that, they want the court to look into this, and of course the court denied that the petition. So this, at least how these cases have turned out, is still the law, and there are, I think, two. This Galderma case, which was doxycycline, they were delayed release, and the board had construed this to mean release of a drug at a time other than right away, and the district court and the federal circuit said infringement under doctrinal equivalence and won, but in the IPR they found the opposite. So it's just another application, not very remarkable, but an application of the fact that the court is still doing what it started to do in the last year or so with doctrinal equivalence. Excuse me. And in this case, an ANDA litigation, legal pharmaceutical case, what's a pharmaceutically acceptable fluid, and is it ethanol, and is that equivalent to polyethylene glycol? And the problem here was that ethanol was disclosed in the application, and it was not claimed. And as those of you who remember Johnson & Johnson, that is, I think, fatal. If you disclose something and it's not in your claims, the idea is, well, you could always file a continuation or a divisional, but if it's not in the claims as granted, you are pretty much out of luck at the federal circuit. So again, nothing really, I wouldn't say nothing to see here. This Eli Lilly case, interestingly, it's the same drug, permatrexate. Is it the disodium or the dipotassium salt? And there was an earlier case that governed this with dinitromethamine, and pretty much prosecution history, everything else is consistent with these not making a difference. Same patents as were in the earlier case, same here. There is, in the specification, there was language expressly equating the two species, and here it's not like the polyethylene glycol and ethanol rule. Here this is what we claim, but it's a salt. And because it's a salt, and those are recognized in chemistry to be in somewhat interchangeable, if you say they are, here we had DOE being applied. Last one, sovereign immunity. This is state sovereign immunity now, and it's not at all like the Mohawk tribe. It's based on the 11th Amendment, and if you read this, it looks like it has to be suits by citizens of another state. It's been construed by the Supreme Court. If you sue a state, this comes up. This Genentix case is an interesting case of the court splitting the baby in a good way. The state had licensed, through its University of Texas, had licensed a patent, and when the licensee wanted to assert it, Texas said, we're not joining, and they're an indispensable party. And if you remember laws, this sort of procedural law, civil procedural law, you have to have them. One thing you can do, though, is that you can, under Rule 19, you can essentially get them in whether they want to come in or not. And interestingly, you had a split with Judge Newman and Judge Toronto, I think, going down different ways here, but I think it was Judge Prost who wrote the Chief Judge Prost. And basically, yes, there's sovereign immunity. That's fine. When we have that, we're not going to say there isn't. We're not going to say there's an implied obligation when a state actor gets into a license. But you can, under Rule 19, have a suit proceed without the necessary party. But here, the reason is there really is no prejudice to University of Texas by letting the licensee do that. They're the exclusive licensee. Last two, this again, University of Texas seems to be getting in trouble. This is interesting because it's in the IPR context. We already had a case where the Federal Circuit said, the Regents of the University of Minnesota case, that said that if you get into an IPR, if you have a patent in your state, sovereign immunity doesn't count. And when that was petitioned for cert to the Supreme Court, the court denied the petition. The only thing that makes sense to me, since literally this was one of the shortest decisions you'll ever see. There was another one back in the day that was maybe shorter, but basically they have to be looking for a certiorari petition. And you say, well, why would they do that? And it's possible because this Allen v. Cooper case, which is a copyright case, has to do with sovereign immunity and copyright. And North Carolina used copyrighted materials to try to find BlackBerry's flagship, which has a lot of gold in it, they think. And the reason for the suit was Congress in 1990 enacted the Copyright Remedy Clarification Act, which gave them people the right to do that. And that was before, though, the Florida prepaid case, which had to do with patent sovereign immunity. There was a patent case that was a bill that was parallel to the copyright bill. And, basically they used the same argument, the court, but Seminole Tribe Authority versus Florida. Each state is a sovereign entity, and Congress has the right to interfere with that immunity, but only when its intent is clear, and the Constitution permits it. And the Constitution doesn't permit it under the Article 1, the Copyright Clause, the power of Congress. And there was not enough evidence of a pattern of infringement under the Due Process Clause in the 14th Amendment to let Congress intervene. In fact, the Register of Copyrights had very few, maybe 2 or 3 instances in quite a long time where in fact, people were, or states were infringing on copyright. And there was an analogy to bankruptcy cases I don't have time to get into, but that was also unavailing. So it's possible that we have the court thinking about, or the parties thinking about, maybe the Supreme Court has had its appetite whetted for state sovereign immunity cases, and why not roll the dice? So as with most things, we'll see what the court does, and I thank you everybody for spending the time with us, even a little bit time over. If there's any questions, we don't have time for them, but we do have the poll, and I think that'll stay open. You can ask questions, and we will get back to you privately, so lots of questions, and we'll be happy to answer them. Thanks for my co-panelists. Thanks to everybody, and have a good day.